Hi, my name is Andrew Meinzer of Meinzer Law Firm. We take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. The information that I'm about to provide is based on current California law. It's general information and not specific legal advice. Today I'll continue to talk with you a bit about your heirs. This is the 5th video of an 8-part video series. In the most recent prior video, we discussed who will receive all of the assets attributable to the deceased spouse when the surviving spouse dies, not married, with her most recent marriage having ended by the death of her spouse, and having no living children or grandchildren. We discussed that it depends on the following factors: the types of assets, when the deceased spouse died, and the relatives of the deceased spouse who are alive at the death of the surviving spouse. All of this applies to assets that are real property or real estate, and personal property, which is anything other than real estate that has written documentation of ownership and exceeds $10,000 in total value. So, pulling these concepts all together, if the deceased spouse died 15 years or fewer prior to the death of the surviving spouse, then all of the surviving spouse's assets attributable to her deceased spouse will be distributed after the death of the surviving spouse as follows. If there are living children or grandchildren of the deceased spouse living at the death of the surviving spouse, then the living children or grandchildren of the deceased spouse will receive all of the surviving spouse's real property assets attributable to her deceased spouse. The total amount is divided in equal shares based on the number of living children of the deceased spouse and deceased children of the deceased spouse having living children or grandchildren. Each living child of the deceased spouse receiving his equal share, and the equal share of any deceased child of the deceased spouse being subdivided and distributed to that deceased child's children and grandchildren. If there are no living children or grandchildren of the deceased spouse, but there are one or both living parents of the deceased spouse, then the surviving parent of the deceased spouse will receive, or the surviving parents, plural, will split and receive in equal halves all of the surviving spouse's real property assets attributable to her deceased spouse. If no living children, grandchildren, or parents of the deceased spouse, but there are one or more living siblings or nieces or nephews of the deceased spouse, in that case, the surviving siblings, nieces, and nephews will receive all of the surviving spouse's real property assets attributable to her deceased spouse. The total amount is divided in equal shares in the same way as I just discussed a moment ago for the children and grandchildren. Now, if there are no living children, grandchildren, parents, siblings, or nieces or nephews of the deceased spouse, then the heirs, which will be discussed under the next video, of the surviving spouse will receive all of the surviving spouse's real property assets attributable to her deceased spouse. If there are no living children, grandchildren, parents, siblings, nieces or nephews of the deceased spouse, and no heirs of the surviving spouse, the surviving spouse, then the heirs, as discussed in the next video, of the deceased spouse will receive all of the surviving spouse's real property assets attributable to her deceased spouse. And exactly the same thing will occur regarding the surviving spouse's personal property assets attributable to her deceased spouse if the deceased spouse died 5 years or fewer prior to the death of the surviving spouse. Planning ahead for transfer of assets after your death can be very complicated, as illustrated by the foregoing rules, which are quite complicated. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning or transferring assets at death, or even if you just have a question, please contact us and let us take care of you.